Robert Hall on Contracts. I give segments to homeowners associations, contractors, suppliers, and investors. Today I'm going to talk a little bit about contract issues for owners that own single-family residences and the issues in an overall roadmap's quick overview, contract issues when you renovate a building. We're talking about the symbolism of a contract between a contractor and an owner being a journey, an adventure. It is like a road. You start from the beginning, you have planned the trip, and you want to end in a good place. Construction repair contract has twists and turns. It's like a road that has stop signs and left turns and right. And with a little bit of risk management, an ounce of prevention, the owner can have a straight line from the planning to the end. The first issue is, what is a contract? And contracts fall into two parts. The part that's the good part, which is I want to have you do my work and I'm going to pay you some money and it's going to be quality work. That's the good part. And then there's the other part of contracts that lawyers should talk about, and that's risk management, indemnity, warranty, risk management, change orders, correcting work, termination, and attorney's fees. So let's talk about the first good part first. What is a contract? What is a contract? A contract related to a building that you're going to repair or renovate allocates the risk between the owner and the contractor. It provides a level of prediction between the owner and the contractor when something happens down that road, what will happen. And it gives a level of prediction in the case of a dispute. It also records the terms and conditions of the work to be done and the price to be paid. That's a contract. Contracts are classified in construction in three ways, and they're classified based on the pricing involved. And that involves three aspects: lump sum plus a guaranteed price, or a guaranteed price not to exceed. Lump sum means contractor will install roof for X price. There's less risk to the owner for a price increase there. The next type of contract is contractor gets paid all of his costs, whatever they are, and you can imagine how that can fluctuate, plus a fee. And the last one is the contractor gets paid all of his costs up to a certain price, certain guaranteed maximum. Which one the owner should pick is usually dependent upon the skills of the contractor, the background, the references you've done, because there's risk involved in all three. Typically, on a most renovate, simple repair jobs on a single-family residence, a lump sum is the best way to go. As we walk through the road of a contract repair, we have issues that can come up that can be dealt with up front in the contract. Making sure, number one, that you describe the scope of work correctly. That sounds simple, but it requires some communication between the owner and the contractor. Making sure that you describe the contractor's name properly. Again, that sounds really simple. How could you not know the name? You got to look up on the internet to make sure you have the right contracting entity that's licensed. Then there's the issue of which road do we drive down? By that I mean, are we going to use a standard form or a contract that the contractor puts together? From the owner's perspective, the best roadmap to use, a form means a contract that hasn't been signed yet, is one that's prepared by the American Institute of Architects, AIA. That would be my recommendation there. As we walk through the repair job itself, and we've got our AIA document signed, and we've described the scope of work, and we know what the price are going to be, then we get into the actual work itself. Here is where some of the twists and turns in that road to the end can get tricky. What happens if the contractor wants more money? There should be a change order provision dealing with that. What happens if there's delays outside the contractor's control? The contract should state that delays are not the owner's issue unless it's an act of God or something like that, but it could be spelled out in the contract. Extras, change conditions. the contractor should be asked to make sure that he knows the work to be done before he signs the contract to reduce the risk that he's going to ask for more money later, claiming I didn't know of this condition. Pictures, photographs, field notes, previous reports, invoices, anything the owner can come up with will help. As we walk down to the end part of a repair, hopefully with those aspects in mind, you're going to not have to go to the other part of a contract, which is the risk issues. What are those? Really quick, they are arbitration, termination, indemnity, and insurance. Indemnity means shifting risk between the owner to the contractor. If the contractor gets sued, if the owner gets sued based on the contractor's fault, the contractor should protect the owner. That's indemnity. Risk shifting, risk sharing. Insurance, of course, is a policy the owner can buy to protect the owner in the event that there's a leak or a damage or a personal injury. Termination allows the owner to have flexibility to terminate the job when it wants to. And then attorney's fees, in case there's a dispute, the owner can get its attorney's fees in the event of winning the claim. But to go back to the beginning, ounce of prevention is a great word in construction. If you hire an attorney up front who's versed in this area of law, and you get a good contract up front, the risk of a problem down the line goes way down. So this is the end of my segment for today. Robert Hall on contracts. Until next time, happy contracting.